what you're arguing is if there's a charter violation. So you can't say anymore there's no charter violation. I understand the appellant's position. I understand Mr. Potter's position that there was no charter violation. Right? I think the court has heard his argument. But you are now saying, okay, if there's a charter violation, so that's our starting point, here's the remedy. Right? And what I think what is being asked is, what is the remedy? Because what you're telling us is the only available remedy is to strike down the law, and clearly this is a very important law. So what are we left with, right? So let's accept that there is, and we haven't ruled on it. Let's accept that the violation exists. There's a violation of Section 12, and it has not been justified by Section 1. What do we do then? That's what I think we're asking.
Okay. In this case, if Mrs. Smith's, based on the facts of her situation, were found to be so outrageous that there was a charter violation, then if a constitutional exemption was found to be the only available remedy, it should be limited to Mrs. Smith on a standalone basis. At paragraph 46 of my factum, of the appellant's factum, the Supreme Court of Canada has never administered a constitutional exemption and has strongly discouraged the use of a standalone remedy. Lower courts have produced contradictory decisions regarding the use of the remedy, and while standalone remedies have been granted in lower courts and have gone unchallenged by the Crown, the Supreme Court has stated in Orbiter, in Corbier, that it would refuse to expand a constitutional exemption to a standalone remedy. The trial judge's findings were based on principles of anti-discrimination under Section 15 of the Charter. However, no breach of Section 15 was made out, and if there were such a breach, it is on the onus of the accused to make one out. If there were a breach of Mrs. Smith's Section 12 rights, it does not flow from the fact that she is confined to a wheelchair due to her physical disability, but because a distinction can be made between her third offense and the previous two. And the appellants hold that no such distinction exists on the facts. And if a Section 12 breach were found, it is
Excuse
not...
me, counsel, which paragraph are you at?
Paragraph 15. If a Section 12 breach were found, it is not within the scope of the trial judge to limit or alter the sentence imposed under mandatory minimum sentences. The Supreme Court has held that where a constitutional exemption is the only available remedy, it may be applied. However, no such case has yet been found. And based on the facts that have already been set forth in the Nazagalawak decision from 2010, where the behavior of police was so outrageous and yet not found to be egregious enough to warrant a constitutional exemption, we would suggest...
Counsel, I've got it back up here to paragraph 49, where you've said if the Section 12 violation is found in Mrs. Smith's case, it's not based on her having a physical disability, or rather because of third offense. Now, to some extent, that's problematic because it anticipates the reasoning of this court in ruling on the first issue, which we haven't done. But the arguments that have been submitted are to the effect that the violation flows from the fact that she's in a wheelchair and that the wheelchair is less dangerous than a car. That's the nub of the submissions. So I find it difficult to understand how the violation would not, if we find one, would not flow from her disability. I mean, it flows from the fact that she's in a wheelchair.
And the way that the mandatory minimum sentence affects her in this case is not the same way that it would affect another person who is confined to a wheelchair, because presumably the Section 23 was built the way it was in order to deter people from the behavior. So it's not meant so that you reach a third offense. It's meant so that each time the offense gets stricter and stricter to deter you from doing the behavior. So the first time a person who was confined to a wheelchair was pulled over for driving while impaired, they would be fined as a first and lower penalty. And each time that they operate while impaired, they get a stricter penalty. So in this case, if there is a distinction to be found in Mrs. Smith's operating while impaired, it is based on that she was driving a different type of motorized vehicle in her third infraction. Whereas if she hadn't fallen off the horse in 2008, she would still be driving a car. And presumably by the pattern of behavior that she exhibits, she could have been driving while driving in a car. But on her third infraction.
Given the facts of this case, she didn't have to go on the road at all, right? So your argument there, she could have been in a car, but the reality is, if in this case, she would have walked home with her husband if she hadn't fallen off the horse in 2008. So she wouldn't have been in a car. To me, that doesn't seem like she would have gotten in the car and driven across the parking lot home. She would have walked home with her husband because she happens to be confined to a wheelchair and that's not an option for her.
I don't know the details of Mrs. Smith's drinking habits.
But we can't, we're not looking at, the court doesn't look beyond incidents and say, well, is she an habitual drinker? In this particular fact pattern, she was there, her husband walked home, she would have just walked home with her husband, right? The only reason she's caught drinking and driving is because she's confined to a wheelchair. So, I guess what I'm trying to say is, isn't this a case, in using your arguments earlier, isn't this one where the clock should reset? Shouldn't she get her 3 chances as per the mandatory minimums? Isn't this one where Mrs. Smith should start at the beginning and say, look, what you're driving is a motorized vehicle, and you need to be aware that if you drive it while drunk and cause a risk to others, you're going to start with a fine, you're going to move on to 30 days, and you get to 120 days?
I understand the policy behind your argument. However, according to the letter of the law, a motorized wheelchair is not distinct from other types of motor vehicles, and Mrs. Smith's behavior has not changed, despite the fact that she has been given penalties to try and deter her from this behavior.
But it's been 6 years. Doesn't that, to you, indicate some sort of gap? It's been 6 years without her being in a vehicle driving drunk, right?
Again, the case law would suggest that there is no distinction to be made based on a gap. The case law of Smith 2010.
I guess what I struggle with is because in court, if the difference between a first offense and a second offense is in a 5-year gap, there's a policy they'll say, well, we'll take that into account. Now I agree with you that the sentencing provisions don't say anything about, look, it's been more than 5 years, then we don't treat them as harshly, but in case of Mrs. Smith, should we be focusing on the letter of the law in this case? Isn't this why we have Section 12 and we look at the broader picture? Doesn't she deserve, I don't know, like a bit of fairness from the judicial system?
The appellant submits that she should be held accountable to her behavior in as much as any citizen who goes out and engages in social drinking should act socially responsibly. And I would just point out that in the case of Aaron Smith, 2010, there was 18 years between the offenses, and he was still held accountable for that behavior. And if it pleases the court, I'd like to conclude. Mrs. Smith's behavior on the night in question created a significant danger to the public. The act in question constitutes her 3rd offense of operating while impaired, which demonstrates a pattern of behavior that is antisocial. The provisions of Section 253 of the Criminal Code were put in place to address such antisocial behavior. If Mrs. Smith wishes to engage in the privilege of social drinking, she is held to the same standards as other members of the public in that she is expected to plan her evening in a way that includes a safe home plan. The appropriate remedy in the case that a Section 12 charter breach is made out is to strike the law down under Section 52 of the Constitution Act 1982. However, the provisions of Section 253 of the Criminal Code are constitutional overall, and the unique circumstances of Mrs. Smith's case are not so egregious as to warrant the use of a constitutional exemption for the first time ever at this level of court for a class of people for whom a breach has not been shown. And respectfully, the order sought by the appellant is that the appeal should be allowed and the mandatory minimum sentence applied.
Thank you. Any further questions?
Thank you, counsel. Ms. Tracy?
Good afternoon. Again, my name is Maddie Tracy, and I'll be speaking on the issue of cruel and unusual punishment on behalf of the respondent. The issue at hand is whether Mrs. Smith would be cruelly and unusually punished if she was handed the mandatory minimum sentence for driving her wheelchair for a 3rd time while under the influence of alcohol. There are 3 key issues here. They are the difference between wheelchairs and traditional motorized vehicles, the difference between her first 2 offenses and this offense, and the appropriate charge for Mrs. Smith. This has to be done while keeping in mind that we should be guided by charter values of equality. As the standard of review for the appeal is correctness, the respondent agrees with the decision of the learned trial judge in finding that there was a breach of her Section 12 right, which cannot be saved by Section 1. So I'll begin with paragraph 5 of my factum. In the Crown versus Smith, Justice Lamerzi then was stated for the majority that the effect of a punishment must not be grossly disproportionate to what would have been appropriate. If not, that punishment is cruel and unusual.
Counsel, just to be clear on one point, you're conceding that generally as applied to cars, the section is constitutional.
Yes. As a test to determine if the punishment is grossly disproportionate, this was laid out in the Crown versus Latimer. I draw your attention to paragraph 7 of our factum, which outlines the factors of this test, and I will begin with the gravity of the offense. The gravity of driving under the influence is severe. There can be serious consequences that result in high penalties, particularly when an offender endangers the lives of others. However, the gravity of what Mrs. Smith actually did in driving her motorized wheelchair is what needs to be considered. The issue here is that driving a motorized wheelchair is not analogous to driving a traditional motorized vehicle.
So, counsel, what about a scooter?
A scooter?
Scooters aren't likely to cause as much harm as a car. They're lighter than a car. The person driving the scooter is likely to be injured.
Yes. The respondent submits that if a person was dependent on a motorized scooter in the same way that Mrs. Smith is dependent
No,
on...
I'm just talking about a scooter. The point being that there are all sorts of things that are different kinds of motor vehicles. A tractor trailer is very dangerous. A Hummer is very dangerous to others. A smart car isn't quite as dangerous to others. A scooter is less dangerous to others. A moped is less dangerous to others. I mean, where are we to draw the line here?
The respondent submits that the line should be drawn when someone depends on a motor vehicle. For this argument, I'll focus on that why they're different, and then
well, I'm not sure that that's a right under the first factor. The gravity of the offense, I think, goes to the likely risk to others. Whether or not they depend on it may go to the personal characteristics of the offender. But here the question is how serious is driving a wheelchair? That's your first argument. And I'm suggesting, well, it's really not that different from driving a scooter or driving a moped.
If I could build on that for a second, counsel. Wasn't your statement that driving a motorized vehicle is not analogous to driving a traditional motor vehicle, wasn't that dealt with in the Shanahan case? Didn't a trial judge look at that in detail and say that yes, that this is okay, like they are analogous? Didn't he?
Yes.
Are you differentiating that case somehow?
Yes, we do differentiate that case in that Mr. Shanahan was not relied solely on the motorized wheelchairs. He was able to walk up to 150 meters, and that wheelchair was his mother's wheelchair.
So what you're saying in response to the justice is that it's really when you're confined to a wheelchair, that's what you're focusing on. It's the confinement, right? When you're completely 100% reliant on a wheelchair, it's no longer analogous to a traditional motor vehicle.
Yes.
And what happens if I live way out in the country where my only means of transport is a motor vehicle? Am I not confined to that? Am I not stuck with that vehicle? Do I have no option but to use that vehicle if I wanted to get anywhere?
The respondent submits that there would be other options, like taxis or...
Let's be realistic. If I live in a rural community, there are no taxis. There are no, there is no, the reality is that certain taxis are only available in cities. The city, it's a function of living in a city, not living in a rural community, right? In some places, the only way to get around is a motor vehicle. And so, in many ways, I'm stuck. If I want to get anywhere, I have to drive.
The criminal code would still apply in the country or rural areas, and that wouldn't be able to be struck down as this is a valid law with a valid purpose to protect public safety. To drive a traditional motorized vehicle, others would be in danger, regardless of whether you're confined to that motorized vehicle or not. So I'd like to draw your attention to why motorized vehicles aren't as dangerous, or motorized wheelchairs aren't as dangerous. Traditional motorized vehicles are capable of much higher speeds. They have the capacity of carrying passengers, and they weigh significantly more.
So this is a question that was asked earlier. What are we talking about? What's the high speed on a motorized wheelchair then?
From my research, the highest I can find is 9 miles per hour, but that's a scooter. The highest wheelchair I could find was 3.5.
And
Miles per hour.
Miles per hour.
Yes.
So the 5,
The highest
5, 6
scooter would be
kilometers
13.5 kilometers per hour.
so here's where I'm struggling. What you're doing right now is you're introducing fresh evidence, right? The appellant had no chance to respond to this. Nothing's before the court on that. This is just research you've done. You have nothing to present to us.
I do have,
And have you given that to the appellant?
They are aware of
They're
that.
aware of the research you've done?
Yes.
And do you have any objections to us seeing whatever she's prepared to present? Is that a no?
No.
So if you want to give us a signature? So you can continue while we look at this.
Another difference which furthers the point is the need for license, registration, and insurance of such vehicles. If Parliament intended for wheelchairs to be considered as traditional motorized vehicles and permitted them on roadways, they should be subject to the same requirements as traditional motorized vehicles. For these reasons, it follows that the circumstances surrounding the 2004 charges are different than the 2010 charge and are not comparable. And the 2010 circumstances should be looked at in isolation.
Counsel, if I have a bicycle and it has a motor on it, not even a scooter, but a bicycle with a motor on it, which exists now, right? And I get drunk and I drive this, I become impaired, and I drive this while impaired. Doesn't that, so I don't need a license to drive this bicycle, right? I'm on a public roadway. Couldn't the police charge me with impaired driving if I'm on a motorized bicycle, on an electric bicycle?
Yes, and as this respondent submits that because no one would be confined to a bike